My goodness, I've done this enough. You'd think I would unmute myself, but welcome everyone this evening to our condo catch-up. Thanks everyone for attending. I'm Eileen. I'm Eileen Bowles. I'm a director on the board for CCI Eastern Ontario. I'm also a co-chair of the Education Committee, and I'm a condo manager here in Ottawa. You'll see on our screen, we have our presenters here, which we'll introduce everyone here in just a second. I also have on the bottom right-hand corner of the screen is Shelley Seavey with us. She's going to help moderate this evening. We have lots of great topics that we're going to chat about with regards to condo catch-up, everything that's happening in the condo world right now. Before we get started, I wanted to go over just a couple of Zoom procedures with you guys. You probably saw it there in our little slideshow. I wanted to let you know we are recording this, so we will have this video available for you to view afterwards or to share with fellow board members or condo owners. It'll be on our website. You can have a peek at that. The audience is going to be muted this evening, and your videos are going to be off for this presentation. We're going to ask that you use the question and answer feature at the bottom of your screen rather than the chat feature to raise any questions. So yeah, don't use your chat, use the question and answer at the bottom. We're going to look at the questions at the end of the presentations as we go, and then we'll answer them all at that time. Feel free at any point during the presentation to pop your questions into the Q&A, and we'll gladly answer those. Quick little disclaimer that the information you're being provided today is general information, and the primary purpose of this webinar is to educate and to inform. The webinar does not constitute professional legal advice or services, so we ask that you please consult legal counsel for an opinion about your specific situation. The webinar is not intended to provide you with opinions that would protect you under Section 37 of the Act. So we also want to advise you that the references to the Condo Act or any other legislation that we talk about here tonight are in reference to Ontario legislation. Okay.
Thank you, Eileen. Before we move into the presentations, we would like to extend our thanks and appreciation to our presenters and our sponsors this evening. Thank you to our presenters, Cheryl Wood. Thank you for joining from Davidson Houle Allen. We also have Megan Malloy from Elia Associates Condominium Law. Nancy Houle, also from Davidson Houle Allen. And we have Noah Johnson from Sentinel Management. Thank you also to our sponsors this evening. We would like to open this evening up and we appreciate the sponsors this evening, which are Carleton Electric, Davidson Houle Allen, Douglas Fire Safety Systems, Elia Associates Condominium Lawyers, Normac, Sentinel Management, and Upperby.
Excellent, thanks, Shelley. So this evening, as I mentioned just quickly earlier, that our experts this evening are going to discuss the recent changes in the condominium industry as they may relate to your condo. They're going to include changes to the jurisdiction of the Condominium Authority Tribunal. You've probably heard it referred to as the CAT. We're going to speak about virtual meetings, and we're also going to discuss short-term rentals. We also understand that COVID-19 is a very hot topic now, and I guess over the last year. So that's probably something that's on everyone's mind. And we want to offer some at this meeting. We're going to offer a little bit of time at the end of our presentations. We're going to open up the floor to any questions you might have about COVID-19 and its impact on your condos. So these changes that we're going to touch on this evening impact the condominium corporation. So we hope that the information provided will help navigate the ever-changing condo world. We want to thank you, everyone, for joining us here this evening. We have a great turnout. Thank you. And like I mentioned earlier, there's going to be plenty of opportunity for questions and answers at the end, and keep them coming. We look forward to those. So we're going to start off our presentations with Nancy.
Eileen, don't start the slideshow yet, because
okay.
I noticed something and I just had to raise it just because it's the way my mind works. I feel like we should play bingo on the screen. There are two purple sweaters. There are two black and white sweaters, and there are two black shirts. Did you notice that? So it's like we could play bingo on this screen. So well done, everybody, for coordinating our attire this evening. Good job. Sorry, Eileen, it was just something that popped into my mind, a really fun start. So
we didn't even call each other beforehand to coordinate either.
Well done.
Excellent. So Nancy, if you're ready, we'll go in there with your presentation.
Sounds great, Eileen. So I understand you're going to go ahead and screen share for us, and you'll flip our slides as we go.
You bet. Yeah, you hold on 2 seconds. Here.
There we go. Fantastic. So folks, I'm going to start us off with virtual meetings. And I have to say, I am very much enjoying the virtual meetings. I do miss, of course, getting together with people. I miss the camaraderie before and after a meeting, but there have been a lot of really positive things that have come out of virtual meetings. And at the end, we'll talk about some tips and tricks, and we're going to have also some input from Noah on some of the experiences that he's had from the property management side, but just a couple of interesting things that I've seen happen as a result of virtual meetings. In one case, we had an individual attend their first ever condominium AGM in over 20 years. Previously, they couldn't attend or didn't feel that they could adequately attend because they were hearing impaired. So we offer closed captioning services at that particular meeting, and they were very excited to attend their first ever AGM. In other cases, we've had owners attending from as far away as Mongolia, some in Australia, some in New Zealand, all over Europe, and even just across the provinces. So virtual meetings, while they may not be exactly what we're used to in the condo world, there are some pretty good benefits for these meetings. And one of the questions that we received in advance of tonight was, do we think that we're going to see these meetings continue long term? I think yes. And I think everybody on this call would probably agree. Not every meeting is going to be virtual. Maybe not even the majority of the meetings are virtual. We don't know really yet what it's going to look like, but I really do believe that we're going to see virtual meetings here to stay in one form or another, whether pure virtual or whether hybrid. This is a new wave that came down, and it's really opened up a lot of doors for everybody. So my goal today is to talk about the top 10 considerations for a smooth virtual meeting. And I'm going to start off with the top 5 legal considerations and then the top 5 practical considerations. As you can see on this screen here, this is just a snapshot of some of the individuals at my office. We were having a team meeting and we were playing around with some of the fun features on Teams. So we'll talk a little bit later about various platforms. This is the Teams platform example here that I just wanted to share with you as a fun caption. So we'll go to our first slide. Top legal considerations. The very first one to think about, is your corporation legally permitted to hold a virtual meeting? For now, the answer in Ontario, yes. All condominium corporations are legally permitted to hold a virtual meeting at this point in time up until May 31st. We do know that the government has passed temporary legislation allowing for virtual meetings across the board, across the province. We also know right now that there's a sunset on that of May 31st. But again, we also know that the government is looking at potentially making this permanent. Various organizations, including CCI, the CCI Ontario Legislative Review Committee, have made submissions to the government to keep this long term, but to give us some time, a temporary transition, if you would, an extension of this deadline, to propose the types of changes in the legislation that we would like to see to make these meetings effective and valuable for the community. So anticipate that we're going to see something from the government in the coming couple of months as to where we're going to go from here. But from now until May 31st, you're good to go. Now, what if the legislation doesn't carry on allowing virtual meetings? What you want to be thinking about right now is to get your virtual meeting and electronic voting bylaws in place. Those bylaws are necessary in the event the legislation doesn't continue. So it can't hurt to have them. Reach out to your local council and talk to them about getting that bylaw passed at one of your upcoming meetings. So that's your first consideration. Next, the validity of the meeting cannot be lost. Even though we're moving to a virtual platform, you still need to make sure that all of your compliances with respect to the Act and your governing documents are met. You still need to make sure your pre-notice is sent out. You still need to make sure your notice is sent out, your 35-day period, your 15-day period. In those documents, you have to make sure that you're fully explaining how the meeting is going to proceed, that it's going to be on a virtual platform. You also have to make sure that the nature of your meeting on the particular platform is going to comply with the requirements to ensure it's a valid meeting. For example, that you have a way of confirming exactly who is registering into the meeting and exactly who is attending the meeting. If there is a general link to a Zoom session, for example, that is being sent out, you need to make sure that those who are accessing that link, when they register, you can confirm who they are in the background, and that when they show up on that general link, that you know who they are. So your validity of the meeting, the registration, the attendance has to still be compliant to meet the technical requirements of your provisions of the Act and your governing documents. In addition, the voting processes. You have to make sure that the voting processes are valid and properly followed. So making sure that you have an audit trail of the votes that are being taken. Whatever platform you choose, you have to make sure that you can validly confirm the results of any of your voting that takes place during the meeting. Let's move on to the next slide, Eileen. Slide number 3, or provision number 3. Ensure that the chosen platform to host your meeting will allow for compliance with meeting procedure. So just a few minutes ago, or just a moment ago, we talked about ensuring that your meeting itself is valid. So your registration, your attendance, your voting, etc. But in addition to the standard provisions to have a valid meeting, you also have to make sure that you have a process that allows for proper procedure to happen. Some condominium corporations choose to follow Robert's Rules of Orders. Others, which are the ones that I mostly take care of, are Nathan's and Wainberg's Rules of Order for company meetings. So you want to make sure that your chosen platform is going to allow you to follow the standard rules of order for your condominium corporation and to ensure the standard in the industry. For example, do you have a platform that allows people to raise hands, to take questions from the floor? Do you have a proper platform to allow for a mover and a seconder of your motions? Do you have a platform that allows for full participation of all of your attendees? One that allows for nominations for elections from the floor? This is an interesting one, and one that was amended and adapted as virtual meetings became more and more the norm. We had a lot of questions about this early on. Well, how do I allow for nominations from the floor? If we're doing everything that we can in advance by proxy, how do I make sure that if somebody wants to nominate themselves from the floor, that they be included? Well, it's a very important consideration in the type of host setting that you choose to make sure that that can happen. Next, allowing for live voting. I'll bring that up a little bit later on again when I talk about ensuring that you speak to your service provider about the various options that are available to you. So again, making sure that you look at all of the various features on the platform that you choose to make sure that you are legally compliant with the provisions of your governing documents and also meeting process. We'll talk about a little bit later about some of the other features, but for now, just making sure that you've met process. Let's go to item number 4, ensuring that the process for choosing a chair and scrutineer is compliant with your governing documents, and that the chair has sufficient expertise to ensure procedural compliance during the meeting. So as most of you may have done over the past in previous AGMs when you were doing it live, you would often choose your chair the night of the meeting if it wasn't going to be the president, or you would choose your scrutineers the night of the meeting. Well, with virtual meetings, that really just isn't a practical reality. So what you need to do is make sure that the process that you're following for your virtual meeting sets out how the chair and scrutineers will be determined in advance of your meeting, so that you don't show up at the meeting that evening and have concerns raised about how the votes or any results are going to be scrutinized the night of the meeting. In many cases, it's just a matter of including in your advanced meeting packages a description of how the chair and scrutineers are going to be chosen. And then, of course, chairing a virtual meeting is different than chairing a live meeting. So you want to make sure that your chair is comfortable with all of the various considerations that we've just talked about and how the platform that you're using will allow the chair to make sure that those considerations are followed and that you're compliant with the rules of procedure as you go along. If your chair isn't quite comfortable, then you can have an additional person with them, the host or your scrutineer may be helping at some point in time if they're the one who is most familiar, but you definitely want to make sure that whether it's just the chair alone or with a host, that you understand how to use your functions to ensure procedural compliance. So let's move next to my fifth top legal consideration. Make sure your meeting is actually a meeting. This is an important one, and this is stemming from some creative solutions and creative ideas that we've seen come out in the industry. And I think they're fantastic ideas, which may sometimes need a little bit of tweaking to make sure that the meeting is a meeting. For example, we've seen a couple of cases where notices have been sent around and owners have been advised you must vote by proxy. You are not permitted to attend a meeting. No meeting will be called. You can only vote by proxy, right? Well, the CCI Ontario Legislative Review Committee, we talked about that quite a bit when we were doing our submissions to the government on what a virtual meeting and virtual meeting provisions should look like. Because of course, participation at the meeting is one of the most important criteria for owners to participate in their condominium and to be active members and engage in their condominium complex. So you can still have meetings by way of proxies, so to speak, as long as you still actually call and hold the meeting to allow those individuals who may choose to come to the meeting the opportunity to do so. So if you're talking about a proxy meeting or considering a proxy meeting where the majority of people vote in advance using their proxy, speak to your council or your property manager about the processes that you're going to want to follow to ensure that you still have that meeting itself called and held. Even if at the end of the day, the room looks like this picture on screen, well, except that all the people there would be on computer instead of live. But if your picture is just the board of directors and everybody else has only attended by proxy, that's great. As long as you have given the owners the opportunity to attend, you have called the meeting, you are holding the meeting so that a meeting is actually occurring. So key point, make sure your meeting is actually a meeting with whatever process you decide to follow. So those
Nancy,
are, yes,
sorry
go ahead,
to interrupt. I have a quick question here. We have a condominium that's being advised to remove from the declaration of the ability to nominate from the floor, not because of the virtual meeting, but because of legal counsel does not believe it is a good model and does not generate good candidates. Is this a trend with other CCCs?
No, and I can say I've never, in fact, seen other condominium corporations removing from the declaration and bylaws the opportunity to run from the floor. Standard rules of order, Nathan and Weinberg's, as well as Robert, allow for you to present yourself from the floor. Arguably, so does the Condominium Act. The Condominium Act arguably does allow you to present yourself from the floor as well. So you'd want to do a careful review to determine whether or not your declaration and bylaws are in contravention of those provisions of the Act that arguably allow someone to stand from the floor. It's a combination of 3 or 4 different provisions that, in my view, if you take a look at them, allows an owner to present themselves from the floor. Again, all council have different ideas and approaches with respect to how those provisions should be interpreted. So obviously speak to your legal counsel about what I'm saying here this evening if your legal counsel isn't in agreement. But in my view, everybody should have an entitlement to run from the floor. Great question, Shelley. Thank you. So let's now talk about some practical considerations. First of all, choose a provider that suits your needs. So for example, I was talking a little bit earlier on about making sure that the procedural requirements are met, right? So that you have all the functions that you need for voting, for raising hands, etc. You also want to make sure that you and your service provider agree on what your meeting should look like. For example, in some cases, some hosts of meetings allow owners to show themselves on screen. That has the effect sometimes of allowing for individuals to feel more engaged in their meeting, to feel like they can see each other and be more participatory in the meeting. Other providers don't allow individuals to show themselves on screen, and it's only the panelists. For a large condominium corporation, not having everybody on screen may be your best tool. For a small condo, having everybody on screen may be your best choice. So choose a provider that is going to suit what you want your meeting to look like, and have a really good discussion with them at the beginning when you're selecting your provider about how you see your meeting unfolding. Then understand, or as part of that discussion, understand the system you'll be using and how you want to use it. I always say it's fun to play around with some of your capabilities. Maybe you want to look like you're on a movie theater. Maybe you want to look like you're on an old-fashioned television station. Those are just some of the fun functions that you can play around with your capabilities. More importantly, of course, is understanding the key functions and features that you may use for your meeting. For example, if we look at the Zoom platform, how do you want to use the question and answer, or do you even want to use the question and answer? Some service providers really like it if you do all of your questions and answers in the Q&A function. Other service providers don't like the Q&A function and prefer to have all of the meeting live on screen. Some service providers prefer to have the questions in the chat. Other service providers don't like to have questions in the chat. My personal preference, for example, if I'm hosting and chairing a meeting, is to have no Q&A written, everything live, so that we all participate in the meeting as a live semblance of a real meeting, to do our best to simulate an actual live meeting. And the chat function is used only for technical questions. And I just happened to see pop up, what do we mean by service provider? Great question. The service provider, I mean, is your host, the company who's going to host your meeting online if you choose to have a host. If you're hosting it yourself, then you would be looking at which electronic platform are we going to use, which voting platform are we going to use. So the type of service provider could be a one-stop shop. We're going to go with a Get Quorum, a Condo Voter, a Canada Webinar Services. Those are one-stop shops where they'll do everything for you, all the way down to your in-house solution where you've chosen to do it yourself using Zoom or Teams with whatever voting platform that you are choosing to make sure that you have a safe and secure audit trail of your votes. And then legal counsel, various law firms are also providing hosting and sharing services as a combined service. So that's what a service provider can mean in this context. So last, of course, under number 7, how do you want to use these functions, and making sure that you're comfortable with the decisions you make on how to use them. Next, and I think I'm going on a little bit longer than I should, so I'll just try and wrap it up a little bit here. And Eileen or Shelley, feel free to wave at me if I'm going too long here. I could talk about virtual meetings all night. Final preparation and rehearsal, make sure you do that. If you have not yet done a virtual meeting, contact your service provider, or if it's just you and your board doing your in-house setup, check your hardware, check your software, make sure if you want to share screen, share documents on screen, that you get all that information in advance. You test out your share screen functions. For example, on the Zoom platform here, if you want to share audio and video, there's a couple of buttons you need to press. You want to be familiar with how to do that. And then think about how you want to educate your owners on using the software for the meeting. Do you want to have a practice session in advance with your owners? Do you want to have a video starting about an hour, half an hour before the meeting starts to let owners see the various features? Do you want to educate them 10 minutes before the meeting starts, just so that everybody is comfortable and familiar with what they're going to do in the meeting? How are they going to vote? How are they going to raise their hands? So think about how to educate your owners. The key issues that you want to address at the very beginning of your meeting. So you're just about to start your meeting before you get into some of the substance of the nature of the business. Confirm whether or not you're recording the meeting. If you are recording the meeting, confirm who's going to be entitled to that recording. Typically, when I chair a meeting, I announce that the recording does not form part of the records of the corporation, and it's solely for the purposes of the minute taker. I know that some corporations do things a little bit differently across the province, so whatever your process is, make sure that you confirm that at the start of your meeting. Are you allowed to use, or do you have the services of closed captions? If you do, how can an owner access them? Confirm who is your chair, confirm who is your scrutineer, and fully explain the voting processes at the beginning so people aren't nervous about what their expectations are for voting as they start to go through. And my number 10 consideration at the end to ensure a smooth virtual meeting is communicate, communicate, communicate. Again, with virtual meetings still being somewhat new to many owners, the more information you can provide to them about how these meetings can be fantastic, can be just as good as a live meeting as long as we all get together and work together. The more you communicate that to them, the more the anxiety level will go down. And after their first meeting, owners will be delighted. They'll have had a great experience, and you'll be surprised at how many condos and owners say, hey, let's do this again. So those are my top 10 tips. I just thought maybe before we turn it back to anyone else, Noah, did you have anything I missed that you wanted to add from practical considerations?
Yeah, sure. Thanks. It's a great overview. I think our feedback has been, from a manager's perspective, largely the same. Of course, we're seeing a higher turnout at meetings. We're also seeing a little bit more of an increase in participation as well. So I think it's really good to see that virtual meetings seem to be working. Another good practical consideration, at least again from our stance, has been the ease of passing bylaws. So everybody has those bylaws that they can't get or some people have the bylaws they can't get support of ownership. So we've had a couple of examples for insurance deductible bylaws, standard unit bylaws, where since we passed the e-meeting bylaw, we were able to do an electronic vote and pass the bylaws with a little bit more ease. So that's been a positive for sure. I think our excitement is in the hybrid meeting potential, right? So you mentioned, Nancy, somebody from Mongolia participating in a meeting. So obviously in the future, one day when COVID's not a thing, it's going to be great to be able to meet together, have a physical meeting, but also bring people that are maybe around the world and have a hybrid meeting. So that's something we're looking forward to. I think just a few more general tips, lots of things that Nancy's already covered. Communication is obviously key. I know our stance has been trying to educate and give as much resources to people as possible to be able to have a successful virtual meeting. So, a year ago when everybody first started hearing the word Zoom, everybody was, worried and they didn't know how to log on or what to do. So I think it's important to have those conversations and be able to educate, potentially the older population in buildings, how they can get onto the meetings and how they can really participate to their full ability. Of course, recording meetings is also a benefit. It's important, yes, to disclose that if the meeting is being recorded, and it can also be helpful to minutes, whether that's for a savings potentially in typing up the minutes and having somebody sit through the meeting, but it's also nice to be able to go back and reference exactly what's happened. And the last thing I would say, just from, again, a practical perspective, is the utilization of screen sharing abilities. So I think that's been a really positive thing for us as well. And an example of an insurance deductible bylaw, it's nice to be able to put on the screen kind of a flow chart and what can happen in a water leak or an issue without the insurance deductible bylaw, and how the corporation's insurance can be exposed. So I know we had a situation where we put a sort of a pictograph and water going from a top unit down into units below. So I think it was helpful to give a different visual in that regard. So yeah, that's from my stance. Eileen, if you want to flip the slide, I can talk now maybe about short-term rentals. Okay, so short-term rentals, concerns, potential benefits, and tips. Obviously, as a starting point, this is a bit of a contentious issue. I think that this was a debate that was positive or was prevalent in the industry a while ago, and it kind of subsided a bit. But I think, from my stance, I think the most important thing is to be able to have conversations with your boards about short-term rentals and how they can kind of exist or maybe not exist within your property. So obviously, I'll first outline some concerns, then I'll get into some benefits and maybe some practical tips for everybody to consider. Obviously, concerns, lots of them may be obvious. Safety and security. So that's a common concern we see. Who's in my building? Who has codes for our building? How do we know who's coming and going? Another example would be additional wear and tear on common elements, right? So if you have amenities, pools, gyms, things like that, there's likely going to be more use of those amenities by visitors. Also site services, right? So potentially there could be an increased risk for people flushing things down the toilet, or not as much of a regard for the amenities and site services as an owner may have. As well as compliance issues. So in our experience, there has been an increase in some buildings because of things like partying, smoking, noise, and that's largely because, again, these people are coming on vacation. They may not be aware of the governing documents or rules that they need to follow, and we've seen compliance issues kind of increase in that regard, as well as municipal requirements. So lots of the times when we deal with boards, they don't really realize the municipality's involvement in short-term rentals. The municipality has requirements. There's things that we can and cannot do. And even, as far as a condo wanting to prohibit or allow short-term rentals, you should always check with the municipal requirements, because it might do some of the legwork for you. Next slide, thank you. Also, just from a liability insurance risk, potentially, more of a risky endeavor for your insurance. It's important to make sure that the corporation's insurance broker knows, especially if there is a significant amount of short-term rentals, as well as from the owner's stance. There is insurances out there for unit owners that are using their units as a short-term rental, and it's important that insurance is being maintained properly. Also, the single family dwelling provision, lots of people are familiar with the fact that many declarations have this provision, and it sort of dictates what what does and does not constitute a single family dwelling. And I think one of my practical, or one of my most important considerations, is just the records of the management company. Everybody knows that whenever there's a unit that's being leased, the owner has an obligation to notify management and give some information on that tenant. And I think to me, it's a little bit uneasy if units are being rented on a short-term basis. We don't know who the occupant is at all times. And in a situation where there's an emergency or a flood, it is a bit of a concern. And then lastly, concerns over COVID-19, right? Lots of people coming and going from buildings. We're not sure often who's there unless you have proper screening in place, but COVID also brings sort of a different level of concern as well. So on the flip side of it, there is some benefits to short-term rentals. And again, every corporation is different, and then these things all have to be kind of evaluated on your individual needs. One thing that's interesting to note is a company, Airbnb, who you're all probably familiar with. They have a program that's called the Airbnb Friendly Buildings Program. So what it is it allows buildings to exist kind of with short-term rentals and follow certain rules and regulations and be as compliant. I think the most useful part about it is also the dashboard. So, you can go into your dashboard and you can work with management to see, okay, are people following the regulations? But a step further is you can actually see complaints, other complaints from other residents in the building, and how sort of the short-term rental units are existing within your condo. Next, revenue stream for condos, right? So, for example, if you have 2 guest suites, it's easy to put them on short-term rental websites, Airbnb or whatever, to get them rented, and it could be a good revenue stream for the corporation. And I think, again, there's a bit of an optimistic side of me in this, is that, maybe increased regulation is what's required. I'll talk about some of the proposed regulations that may be enacted, but maybe increased regulation and knowing exactly who's in the building at what times would be a benefit, and would allow us to have short-term rentals exist a little bit easier. Another benefit, again, potentially more appealing to investors. You can think of a condo, downtown Ottawa or downtown Toronto in convenient locations. That might be appealing to investors. You could also argue the opposite, right? Maybe it's less appealing to investors if there's more short-term rentals in a building. And I guess my closing point on just the benefits is there's lots of good people out there, right? So there is potentially an ability for people just to rent units and exist and follow the rules, and things can work harmoniously. Tips. So the next thing I think is important to discuss, and this is sort of some practical considerations for boards to review and discuss. And I think, again, as I mentioned in my opening, You want to be able to discuss these pros and cons or concerns and potential benefits and figure out how short-term rentals will exist in your condo. Again, maybe it's having your guest suites rented out on a short-term basis, or maybe it's passing a rule where you ban them altogether. Every building's a little bit different. Owners are all a little bit different. So it's important to be able to have those conversations. Again, a few more practical tips, signage, right? I think signage is always key. Whether or not there's a rule against short-term rentals or whether there are certain guidelines that must be followed. This is also, there's talk about this in the municipal changes about kind of mandating certain signage. Also, again, as I mentioned, reviewing municipal bylaws. You may have an additional leg to stand on if you're in a situation where you're trying to weave out or get rid of short-term rentals. The municipality may do some of that work for you. Review governing documents. Again, I mentioned the single family dwelling provision, and it's important that you work with legal counsel to ensure that you can pass rules or modify rules as required. Documentation, also a key component of all this, right? On both sides of it, if there is non-compliant units that are being used as short-term rentals, documentation is really key. I think it's also a really good idea to remind owners of these things, right? Education is important, and we remind owners of the tenancy process, their obligations when they have a tenant, but also however your corporation handles short-term rentals. And again, different options. You may want to pass a rule one way or the other, and I think it's important to really have those conversations with legal counsel and your board. Next slide, please, Eileen.
Before we move on there,
Yep.
Somebody had asked here, and I think it's probably good we put this in there. Somebody wanted to know what the single family provision in the declaration specifically means.
Sure, yeah. So Nancy and my lawyer friends that are on with me can tune in, but my understanding is there was a court case in which the judge determined that the single family dwelling and Airbnb short-term rentals aren't really the same thing. Simply put, that if you're using your unit as a short-term rental, it's a hotel-like proposition, and it's in constitution of what the single family dwelling provision actually means. Nancy, I don't know if you want to add.
Yeah, and I'll jump in on the single family part too, Noah. So with respect to the pure definition of single family, the courts did interpret that those provisions back in 2012. It's been a while now, to confirm that a single family, the word single family means essentially related to each other. So blood related, mother, father, child, or the adopted children living with them, or one family or one or two family members living with the existing family, related family members. So if you wanted to move away from that strict definition that was actually upheld by the Court of Appeal back in 2012, you would need to pass a rule to extend that definition to other individuals who may fall within the definition of your definition of family. So hopefully that's helpful. Back over to you, Noah.
Thank you. So municipal bylaws. So this is kind of where there was a big debate, 2 years about short-term rentals, and especially here in Ottawa, what things the city was doing to regulate them and make changes. So in November 2019, City Council voted in favor of regulatory framework for short-term rentals. They had three kind of key components: quality, availability, and affordability. So from the quality stance, they wanted to ensure that proper standards were being met, and what can the city do to ensure those standards are being met? So again, think of property standards, and in the city, their job is to make sure that there are certain standards that are being met in people's homes and outside people's homes. So sort of a similar principle in that. As well as availability is kind of the relationship between short-term rentals and investments. So obviously right now we're in a bit of a crazy housing market, at least here in Ottawa, and I think it kind of extends throughout the province. But what is the relationship between short-term rentals and investment properties, and what can the city do to kind of help and manage this? Again, into my third point of affordability. What will changes from the city's level do to change housing costs? Fast forward to a little bit more recent in times, the City of Ottawa is planning a 3-year trial period to sort of evaluate these things and get some information. A couple of the things the city's doing: additional bylaws officers is being sought after, and this will, again, in time with my third point, you'll see how this kind of connects. Rental housing property management bylaw. So again, property standards, a specific bylaw that dictates what can and cannot happen in a short-term rental. And then lastly, and I think really what the industry needs is an online database, right? So the obligation for owners to register if they are using the unit as a short-term rental, and what that would look like. So again, for bylaw patrols, it's a lot easier if they can go onto an online database and say, okay, this unit's being used as a short-term rental. Are these standards being met? I think lots of people are optimistic, and they hope that the corporations, regardless of what steps the city takes, that the corporations and the condo corporations can take steps to further regulate the use of short-term rentals in the city. So if the condo wants to do certain things, maybe be more specific or more gung-ho on certain provisions, that the condo will still have that ability. So again, all this stuff's new and changing, and it's evolving as time goes on. So it's important that we keep the doors open and we see what happens and what changes. But lastly, I think it's just a helpful thing for everybody to realize there is lots of information on the City of Ottawa's website. So there's tons of reports. There's tons of case studies on Ottawa and other cities that have done different approaches and had different experiences with short-term rentals. Yeah, so that's everything on short-term rentals. Cheryl, I think you're next, unless there's some questions here.
There are a couple questions. Eileen, did you want us to tackle some of these now before we turn over to Cheryl? What do you think is best?
Why don't we tackle a couple of them here before we head over to Cheryl on the updates with the Act. So, Noah, we've got a question here about could a condo board levy a charge to the unit owner if and when the owner puts in place a short-term rental? I imagine in violation of their rules. What do you think there?
Yeah, maybe Nancy, do you want to take this one? I
Sure.
haven't directly
Yeah, and I'm wondering if maybe there's two thoughts here. One of these, it looks like maybe they're saying, if we do allow short-term rentals in our building, could we charge owners who choose to have short-term rentals? And it's a really good question, and we've definitely had a couple of condominium corporations consider this. Now, the key is we have to make sure that we're treating all owners equitably, right? So you can't put in place anything that's like a penalty or a fine if somebody chooses to have a short-term rental versus a long-term rental. So you can't penalize or fine anybody or put in place some sort of charge that would appear to be a penalty or a fine. Now, if the corporation could legitimately say that there were administration costs, so for example, if there's a process in a bylaw that the corporation has put in place on how short-term rentals are going to be regulated in that condominium, which we have seen in some cases, and there's an administrative cost to administering that process, that could then technically be charged back to the owner who is having the STR. Similarly, if there's additional costs for maintenance or upkeep, et cetera, related to that type of a use, then arguably those costs may be able to be charged back to the owners who are using them as an STR. But purely as a revenue source or purely as a mechanism to perhaps dissuade STRs, my view is that no, that would not be in keeping with the provisions of the Act or generally governing documents.
Excellent. Thank you, Nancy and Noah, for that. So yeah, we'll move on to Cheryl with her updates on the Condo Act.
Okay, thanks everyone. I am going to start with, just before I get into the updates to the Act, I'm going to start and touch briefly on a couple of other pieces of legislation where we've seen updates lately, starting with municipal bylaws, just following off what Noah said there. Municipalities, including Ottawa, are implementing legislation to address short-term rentals. Noah reviewed the current 3-year trial zoning amendment in Ottawa, but I just wanted to add that we know that many condominiums have their own prohibitions with respect to short-term rentals in their declaration bylaws or rules. DHA has written to the city about these provisions just to confirm that condos have these provisions and to ask the city to ensure that they give consideration to these provisions when they draft the bylaws. And the city did reply to us to confirm that the staff are developing robust protections for condominium corporations that have chosen to prohibit short-term rentals on their property under their own governance rules. And so they confirmed that if a condominium declaration or condominium bylaw prohibits short-term rental use on the premises, the city would not issue a short-term rental host permit for that specific address. Now, we've also been in communication with them as well to confirm that the corporation's rules can address the short-term rental issue, and to just confirm that it should be any of the corporation's governing documents that contain provisions with respect to short-term rentals would be respected within the city bylaws. So we're hopeful when that comes into force that condos will be protected there. All right, so Occupiers Liability Act, condominium corporations are considered occupiers of the common elements. So there are some recent changes to the Occupiers Liability Act that are important for condominium corporations and condos insurers to know about. The new change that, in my view, is relevant is the requirement that a claimant for personal injury caused by snow or ice is required to give notice to the defendant, so in this case, the condominium corporation, within 60 days of the incident. The reason for this is to ensure that the condo or the condo's insurer can review the evidence when it's still fresh. So this is an important change in the Occupiers Liability Act. We also have the new Home Warranties Plan Act. There have been some amendments recently with respect to this act. The purpose of this act is to provide protection to purchasers of new homes in Ontario. Over the years, there have been concerns that there might be possible conflicts of interest for Tarion Warranty Corporation, because until recently, Tarion had two roles. One of the roles was to ensure that builders honor statutory warranty protections, and the other was to oversee the licensing and regulation of the new home builders and vendors. So that could create situations of conflict. So one of the recent changes made through the recommendations by the Auditor General was to separate these two functions. So there has been, effective February 1st, 2021, they created a new regulatory authority, the Home Construction Regulatory Authority, that will be overseeing the licensing. And so Tarion and the Home Construction Regulatory Authority will be working side by side, but there is separation there to remove some of the conflicts. So we're hopeful that this will be a key step with respect to consumer protection, because it gives independence, new government oversight, and an increased focus on public education and awareness within this new authority. All right, so those are a couple of the other acts that have seen changes recently. As you know, with respect to the Condominium Act, there were many amendments implemented in November 2017 with respect to the Protecting Condominium Owners Act. The main changes that came into place back in 2017, as you may recall, is providing more information to owners. And I say forms because it was an implementation of many new forms that everyone's been having to get used to. Ensuring training of directors, implementing management certification and oversight, creating the Condominium Authority of Ontario, and creating the Condominium Authority Tribunal. So when these changes came into force, we knew that there would be further amendments implemented. If you're looking at the Act online, you'll see the sections set out and then another section added underneath in gray. These gray sections are the anticipated changes that were to come in the second phase. We had originally thought that these changes would come into force within a year or two. We have seen some changes to the Condominium Act since November 1st, 2017. So in May 2018, there were changes to the Act with respect to electric vehicles. There were also a few changes with respect to forms at that time. And then in January 2020, the forms under the Condominium Act, all but two, were delegated to the CAO to oversee those forms and any amendments to those forms. And then later in 2020, in July 2020, 2 additional forms were added to that. So the Condominium Authority of Ontario now has control over all 19 forms under the Condominium Act. In April or May of last year, you'll remember that there were changes to the Condominium Act with respect to the pandemic. I know Nancy touched on that earlier, so I'm not going to jump into that too much. In October of last year, there were changes with respect to the Condominium Authority Tribunal, and I'm going to leave that to Megan to discuss after me. Just at the beginning of January this year, there were changes to the Condominium Act with respect to the Condominium Guide. And so the Condominium Act has been amended to confirm that the Condominium Authority of Ontario will be responsible for the Residential Condominium Buyer's Guide. And this condo guide is a document that will become a part of the package that a declarant will send out to new condominium purchasers. So those are some of the changes that we have seen made. However, we're 3 years later and some changes haven't been made. So we're still waiting for those. And just as you can see on that slide, when I was talking about the provision being in white and the future changes being in gray, that's just an example of it up on that slide for you, beside Mickey, who's waiting anxiously for the further amendments to the Act. We did receive questions with respect to what these outstanding amendments might look like. So I'm going to give an overview of some of the changes that we're waiting for, some of which in my view we need sooner rather than later. I've broken the changes into 6 different categories just to assist in breaking them down. So one of our advanced questions, I'm going to touch first on the governing documents, and then you'll see it popping up on your screen now, the other categories that I'll touch on as we go through. But one of our advanced questions asked what upcoming changes to the Act should be reflected in amendments to the declaration or bylaws for existing condominium corporation. So these next few amendments give us some guidance on that question. So first, one of the amendments we're looking at is unit entry without notice in an emergency will only be permitted if the corporation's declaration or bylaws permit it. This is a really big change in my view. Once implemented, if a condominium corporation's governing documents, the declaration or bylaws do not permit entry on an emergency basis, then condos won't be able to access those units in an emergency. And just using Noah's example from earlier about the water flowing down in a high rise, if you have a unit where a pipe has burst and nobody's home and you don't have a provision allowing for emergency access, then that's going to be really problematic, especially in situations like this where time is of the essence. So that's one of the amendments you might want to consider in your condo if you don't have one of those provisions. All right, so it will also be possible for an owner, possible to charge back an owner for actual expenses and to add those amounts to the owner's common expenses if permitted by the declaration. This is one of the changes that I hope will come into force sooner rather than later. Some of you may have heard that there's a recent decision of the court, the Amlani decision, and it makes it more challenging to charge back enforcement costs to an owner without a court order. So once this amendment comes into force, we're hopeful that it will resolve some of the confusion that has arisen as a result of the Amlani decision. So if you don't have a strong indemnification provision in your declaration, this is a provision to seek recovery of the costs that are incurred as a result of an owner. Or if you don't have one at all, that's an amendment that you might want to look at. One of the changes to Section 84 of the Act, once it comes into force, owners will need to be notified of any specific additions to the owner's common expenses, so any chargebacks made. And then it also will provide a prescribed procedure for owners to challenge the chargeback if desired. Another key change impacting your governing documents is insurance deductibles. So Section 105 of the Condominium Act has proposed amendments. When they come into force, condominium corporations will no longer be able to pass insurance deductible bylaws. So this means that to extend the circumstances where an owner is responsible for the deductible, there will need to be an amendment to the declaration. There has been some questions about condominium corporations that have existing insurance deductible bylaws. We're not sure yet whether those bylaws will be grandfathered. It is possible, but we just don't know yet. And then one other addition with respect to that's relevant to your governing documents is a prescribed standard unit description. So if condominiums don't have a standard unit bylaw or a sheet from the developer confirming the standard unit for the condominium corporation, there will be a prescribed definition in the Act. Okay, so those are the amendments relevant to your condominium corporation's governing documents. One of the questions was, should we be considering the amendments now or waiting? In my view, condominium corporations can consider these amendments now, and especially with respect to the indemnification provisions. Okay, so shared facilities. This one's really brief. If you have any shared facilities with a neighbor, or if you have two condominium corporations that share certain amenities, there is going to be a mandatory requirement in many cases that you have a shared facilities agreement. For financial matters, there's contemplation of new procurement processes, tendering to be required for certain contracts. That is something that is going to come into play. And I'll touch on it later, but this is one of the areas where the government was asking for some consultation from the industry last March. Various amendments will be coming into play with respect to first-year performance audits. There will be an obligation for that owners be notified of budgets and certain budget overages. There are some proposed amendments with respect to reserve funds, including additional permitted purposes, specific definition of adequate. So it's going to set out right in the Act what the definition of adequate is, and confirmation that an expert opinion would be required if the reserve fund balance falls below a certain prescribed amount. Finally, with respect to finances, if your condominium corporation has money sitting in the reserve fund and you're wondering about investments, there will be some clarifications in the Act with respect to permitted investments, including the CDIC requirement. All right, declarants. There will be limits placed on the legal rights of declarants within the upcoming amendments. There will be enhanced disclosure obligations for declarants, including specifics about first-year reserve fund budgeting. And then new declarations will also have to say how the declarant arrived at the common expense sharing. So in Schedule D to most of your declarations, there's the cost sharing allocation. Sometimes we have to guess how declarants come to that conclusion, but now once these amendments come into force, there will be a requirement for declarant to set out how they came to those numbers. And there will be more detailed requirements with respect to how to make claims for first-year budget deficits as against the declarant. And there will be additional detail with respect to calculating the first-year deficit when you have a phase condominium and subsequent phases come into are then declared. Okay, disputes and breach of obligations. I sort of combined these together. Unreasonable noise will be prohibited, not permitted by the Act when the amendments come into force. And other unreasonable disturbances may also be prohibited by regulation. There will be prescribed mediation and arbitration procedures that are put into place where the corporation has not yet established it by bylaw. And if you get into a situation where you go to arbitration, arbitration awards will be made public. With respect to court orders for compliance, so if you have to go to court over an order for compliance, there's going to be clarification in the act with respect to the rights of the successful party and the collection of the costs. If there is a breach or an offense under the Condominium Act, which I find is very rare, but they are increasing the penalties for that if there is an offense. There is a confirmation that no fines can be charged to owners. This is already a general principle that's out there, but it will be confirmed once that amendment goes into force. And then there's a possibility for increased jurisdiction for the Condominium Authority of Tribunal. So Megan's going to speak about what jurisdiction is now and the recent expansion to that, but it's possible down the road that there might be further increase in the jurisdiction. And then my last note here with respect to upcoming changes, miscellaneous changes, there are new procedures being set out for requisition meetings. There are changes with respect to directors to be elected by non-leased owners. This is probably more familiar to you as the owner occupied position. So there's changes with respect to that position. Changes with respect to repair and maintenance obligations, including a definition of repair and maintenance, which is helpful to have that in the legislation. And then common element modifications, there are some amendments with respect to the minor changes falling within the board's authority and the details on how to calculate the cost of a change. So we don't have any clear indication right now on when the changes that I just discussed will come into force. Again, some of these changes have been in the legislation waiting to come into force since 2017. But I can confirm that last year, the government was looking for feedback from the condo industry with respect to declarant obligations, performance audits, and reserve funds, also procurement and indemnification by owners. So I'm hopeful that that means that the government's considering these changes and looking at how to get them implemented. All right.
Cheryl, I have a couple of questions that are in the chat. So as per the definition of established for things like reasonable level of noise, has there been any definition established?
I don't believe that there's been a definition established, Nance.
No, not yet. But what I'm wondering is if we're gonna see happen is Megan's gonna talk about the CAT, and I'm wondering if the CAT is really gonna be where we're gonna see some interpretation of what that provision means. So maybe we'll wait and see what Megan has to say about that, and we'll come back to it after her presentation.
Okay. We also have any insight what might be considered an adequate level of reserve fund other than zero?
I can tackle that one too if you want, Cheryl.
Sure.
That's a great question. And there's a lot of discussion, especially with various experts at CCI, Sally Thompson being one who worked with the government many years ago to work on what is the definition of adequacy. Justin Tudor as well from Keller Engineering working on that. There are two schools of thought really that are the primary schools of thought on what adequacy should mean. One school of thought is, of course, just as long as you're never reaching below zero and always having a sufficient amount of money in the reserve to meet your obligations. The other school of thought is to ensure that your contributions to the reserve fund remain constant, increasing only by inflation. So you spread the cost amongst past, current, and future owners. We believe at this stage of the game that we're probably going to see definition number 2 as a definition of adequacy. Can't confirm that yet, but that's the feel that we have at the CCI Ontario Legislative Committee of where we see things going. Just a quick note as well on some of Cheryl's points, or the CCI Legislative Review Committee of Ontario is just finishing up some submissions to the CAO and the government on the Auditor General's report on all of these changes coming down the pipe. We're pushing really hard for some of these amendments to come into force, namely the indemnification provisions. And we're asking for some of the provisions to maybe be held back, namely the insurance deductible one that would kill bylaws, unless they can find a way to grandfather them. So hopefully we'll see something soon.
Excellent. Thank you, guys. Why don't we move on to Megan now with her presentation on the Condominium Authority Tribunal.
Thanks, Eileen. So tonight I'm going to be talking about the Condominium Authority Tribunal, which is referred to as the CAT, but is not to be confused with an actual cat. Unfortunately for you all, I will not be using the cat filter for my talk today. But if you have not had the pleasure of watching the lawyer cat Zoom video yet, please do yourself a favor and Google it. So just as a refresher for any of you unfamiliar, the CAT is a fully online administrative tribunal that is governed by the Condominium Act 1998. It was established in November 2017 and has exclusive jurisdiction to hear and make legally binding decisions regarding certain condominium related disputes in Ontario. Since it was launched, the CAT's jurisdiction has been limited to addressing disputes between unit owners and condominiums relating to access to records. However, on October 1st, 2020, the government amended Ontario Regulation 179/17 under the Condominium Act, which had the effect of expanding the jurisdiction of the CAT to handle more types of disputes. So in addition to addressing disputes involving records, as of October 1st, 2020, the CAT is now accepting applications for disputes about provisions in a corporation's governing documents. So the declaration, bylaws, or the rules that relate to pets and other animals. Although I'm not sure what animals people would be keeping in their units that aren't pets. So we'll have to see what comes out of that. The second is vehicles. And there's a long list of what can be interpreted as a vehicle in a condo, including a bus, a tractor, a motorboat, or an aircraft. Parking and storage disputes. So if your neighbor's airplane wings are encroaching on your parking space, you're in luck. The CAT can now help you out. And finally, indemnification or chargebacks relating to any of those items. So again, as of October 1st, 2020, the CAT now has exclusive jurisdiction over disputes regarding those items I just mentioned. So instead of going through mediation, arbitration, or to the courts, as was commonly done, these disputes now have to be brought to the CAT. And onto the next slide, please. So what new types of disputes can be filed? Just some examples here that have been provided actually by the CAT. So the first is disputes about compliance with provisions in the corporation's governing documents. So a condo will be able to file an application against one or more owners because they have not complied with the governing documents, or an owner will be able to file an application directly against one or more other owners or occupants of a unit for failing to comply with the corporation's governing documents. Next is disputes about the consistency or reasonableness of provisions. So an owner will be able to file an application against their corporation if they think that one or more provisions in either the declaration, bylaws, or rules relating to the pets or other animals, vehicles, parking, or storage is unreasonable or inconsistent with the Act. Next is disputes about the applicability of provisions. So an owner will be able to file an application against their corporation if it did not follow the proper process to implement or amend one of its own governing documents. And then finally, disputes about indemnification. So here, both owners and condos are going to be able to file applications relating to provisions in the corporation's governing documents that govern indemnification or compensation related only again to the subjects that fall within the CAT's jurisdiction. I just want to mention as well that Regulation 179/19 expressly provides that there are 3 exceptions to the CAT's jurisdiction over these issues. So the first is where the dispute involves a Section 98 agreement, and that's a written agreement involving an owner's modification of the common elements. So in that case, the dispute can still go to private mediation or arbitration under Section 132 of the Act, or possibly to court if necessary. Second is where the dispute involves an electric vehicle charging system agreement, and that's a written agreement under Section 24.6 of the General Regulation to the Act. In this case, the dispute would still go to private mediation or arbitration. And finally, the third exception is where the dispute triggers section 117 of the Act, and that's a dangerous condition likely to damage property or cause injury to an individual. And where this section is triggered, then the dispute can still go to the Ontario Superior Court of Justice under section 134 of the Act. And as I'm going to get into just a little bit later, I suspect that we may see lots of condos trying to get through this section 117 loophole to escape the CAT's jurisdiction and head straight to the court where they are able to seek 100% recovery of a condo's legal costs from the unit owner, which is currently far from the case of the CAT. And I'll be getting to that more in a minute. Next, who can apply to the CAT? So unit owners, mortgagees, and condo corporations can all make applications to the CAT as long as the subject matter falls within its jurisdiction. From November 2017 to September 2020, I think most, if not all, applications to the CAT were commenced by unit owners disputing or seeking access to records from their condo corporation. With this expanded jurisdiction, we're likely to see even more filings from unit owners against their condos due to the fact there are limited cost consequences for the losing party. It's also likely that more condos will be applying to the CAT since it now has exclusive jurisdiction over these new issues and simply because they have to, or they'll risk getting a court application kicked back to the CAT if they commence it in the wrong jurisdiction. And finally, we will now see owners filing applications against other owners. So it's going to be interesting to see how the CAT handles those applications, which may, I think, not always involve the condominium. So there should be some interesting new decisions coming out of the CAT in the near future involving a bunch of new scenarios. And we're going to have to stay tuned to see how this transfer of jurisdiction goes. And then on to my next slide, please. Authority to award costs. Are there any changes? So the short answer here is no. But I think I have a few more minutes. So just as a refresher, under its existing rules of practice, the CAT can order payment of reasonable expenses or other costs related to the use of the CAT. And that can include tribunal fees, expenses, or other costs directly related to a user's participation in the tribunal process, or expenses or other costs related to behavior during the tribunal process that was unreasonable, or was for an improper purpose, or that caused an unreasonable delay in the matter. The CAT can also order an unsuccessful party to pay the other party's CAT filing fees and reasonable dispute-related expenses, which do not include legal fees. So the CAT does not, as a default rule, award legal costs. In fact, Section 46 of the Rules of Practice explicitly provides that the CAT will not order payment of legal fees unless there are exceptional reasons to do so. So even where a condo corporation is 100% successful in an application to enforce against a unit owner, based on the majority of CAT rulings so far, it is likely that the CAT will award the condo exactly 0% of its legal fees. I believe there was actually one exception in December last year that came out of the CAT where it awarded a condo costs against a unit owner where it found that the case was filed with the CAT for an improper purpose. And in that case, a board member who was a unit owner commenced a test case to the CAT seeking records from the corporation that were actually never denied to him. But instead of withdrawing the application after he received the requested records, he continued to keep the case active for over 6 months, posting relevant messages and documents unrelated to the requested records on the CAT forum that included false or inflammatory accusations about the condo, its legal counsel, and the CAT itself, which delayed the resolution of the matter. So I think that is the sole exceptional circumstance against the unit owner thus far. But recovery of costs of the CAT is an ongoing concern that won't be going away. The expansion of the CAT's jurisdiction to include more complex issues is likely to result in increased costs, especially in complicated matters where parties are going to have to involve experts and pay them for their time. So parties potentially on both sides may choose or be forced into self-representation because of their inability to recover related legal costs. It's also not yet clear whether disputes regarding the indemnification or chargebacks are going to allow the CAT to order recovery of legal costs for the CAT process or just the actual chargeback itself. So I think the hope is that the expansion of the CAT's jurisdiction will also expand the cases where it's willing to award legal costs. but we're just going to have to wait and see what the effects are as more cases are heard in the months to come. So I think, yeah, that's
Sorry,
it. For
Megan,
the cat.
I just want to interrupt for a second, Megan. We had a question in the chat. So just to confirm, can an owner report other owners through the CAT system? And should the corporation suggest that this when complaints are received or come through to the board?
Sure. So yes, I think the expectation is that other owners can report their neighbors for not complying. You know, for example, if there's a noise dispute, some increased noise that doesn't necessarily involve a condo, and yeah, I guess I would defer to the other panelists maybe for their input as well, but I believe that yes, it will be possible. I'm not quite sure in practice how that's going to turn out. A lot of noise disputes or nuisance provisions turn on whether the board and its reasonable discretion believes the noise or the issue to be a nuisance. So in those circumstances, it's possible the condo would still have to be involved, but I don't know if Nancy, you have any comments on.
Yeah, I agree with you, Megan. I think it's going to be probably a limited application in some cases where we do have a situation. I'm just thinking of off the hand where there's a non-compliance by one owner in maintaining their particular side of a unit, and there's no common issue that the corporation would be involved in because there's no common elements, there's no common wall, etc. That perhaps, and the other owner, and it's not a breach of the act, it's not a breach of any of the declaration or the bylaws. So maybe the other owner, if the corporation has gone as far as they can, may say, okay, well, I think it's time now for us just to bring owner versus owner dispute to the corporation. If the corporation has done everything they can to try and resolve it, and there's really no duty left there, then that may be the only alternative.
All right, thank you, Nancy. So can owners go to the CAT regarding cannabis smoke smells coming from another unit and into the hallway and adjoining units if the manager cannot address this?
So I don't think that's going to fall under the jurisdiction of the CAT yet. As I said, pets and other animals, vehicles, parking and storage, and identification or chargebacks. I think the only way that would go to the CAT is if the condo charged back the offending owner for the cost of addressing the cannabis smoke, and the owner wanted to fight that charge back. Not sure if anyone else has a comment on that, but not so far. As Cheryl mentioned, I think this is maybe a little bit of a test to see how the CAT handles the first expansion of its jurisdiction since 2017 now. There's a possibility that it will be expanded further. But yeah, as of right now, you know, potentially, again, as I said, potentially a dangerous condition. Cannabis smoke could impact everyone's health. So your condo corporation would probably commence a compliance application to the Superior Court under 134 of the Act to address that issue.
Perfect. Thank you, Megan. Thanks, Nancy, for helping out there. Some great questions coming in, and keep them coming. We'll take some time at the very end to answer some more questions. Right now, we're going to move on to a few quick topics on COVID and its impact on condos. So I believe, Megan, you're going to start this one off as well?
I think it's me.
Oh, I'm sorry.
I was going to say,
yeah, it's all good. We didn't want to take a whole lot of time tonight just to talk about COVID. I think it's important just to highlight a couple key topics. So we're really going to talk about employment obligations of the corporation, and then also just the obligation with contractors. So first, with employment, obviously condo corporations can be employers in some situations, right? We might have site staff, superintendents, cleaners, concierge. Obviously, there's been changes in some recent updates about screening for contractors and potentially for residents. So it's important to make sure that screening is happening for all your site staff, like any business should. Also, COVID-19 safety plan, right? A reminder, it's important to have that up to date and in place. Right, PPE, things of that nature. Again, this stuff's all mostly reminders for everybody, but we just wanted to kind of hash it and revisit some of these things. And I think the biggest thing about all of COVID, and especially from an employment standpoint, is it's important just to check in with site staff. Right, we all going through a pandemic. Everybody's reacted a little bit different, and our site staff are the people that are on the front lines in there dealing with residents and maintenance issues on the day to day. So it's important that we check in and we make sure everybody's safe and on the same page. Next slide, if you could, Eileen. And then lastly, just obligations and best practices. Again, just kind of a high level summary, contractor obligations, right? You may have capital projects happening in your property. I know ACMO had a webinar today kind of talking about some of those things in a lot of detail, but just reminders that the COVID's still out there. We need to be taking best practices. If you have a consultant involved, make sure that they're aware and there's proper procedures in place. Again, COVID-19 safety plan. If contractors are doing work, it's really important to have a copy of that COVID-19 safety plan and review these types of things. Reminder of in-suite work, contractors going in, again, back to screening and making sure that there's proper screening happening for both the owner whenever work's happening in their unit, as well as the contractor. And I think, again, overall communication's key. So constant reminders, newsletters, and updates to residents about what they can expect is an important aspect. So that's all we have on COVID. We wanted to, again, keep it brief, but if anybody has questions, feel free in the Q&A to raise any of those COVID-related things.
Excellent. Thanks, Noah. That's perfect. It's definitely COVID's definitely something we hear about every day with management. So I'm sure you hear that quite a bit, eh, Noah?
Exactly. Yeah.
Yeah. With the changes, it feels like there's changes every week as well right now. So we got to keep up to date on that. So we're going to move on now to questions and answers. So we'll take at this point questions and answers from our attendees, if you have any. I know we've been kind of touching on those throughout the meeting. Again, please, just a reminder to use the Q&A feature at the bottom of the screen. We do have a question here from Sonia. She's asking, she says, we didn't address if the Condo Corporation can levy a charge to owners who engage in short-term rentals if they're prohibited. And she also wants to know if it would be addressed under the CAT's authority eventually. Who wants to take that one? Cheryl?
Okay, sure, I can jump in on this one. First, it's my view, no, it wouldn't fall under the condominium authority's jurisdiction right now. With respect to chargebacks to owners in violation of the short-term rental provisions, again, condominium corporations can't levy fines. But if there are costs incurred by the corporation as a result of the breaches of the short-term rental provisions, then it's possible, depending on the corporation's indemnification provisions, that they might be able to charge those costs back. And that's an example would be a management's time incurred in preparing letters to the owner. That type of chargeback might be permitted under the corporation's governing documents.
Perfect, thank you. We've got a few more minutes here, so if there's any questions that might be coming in from the floor, please let us know. We'd be happy to answer them.
Looks like we did a pretty good job of answering
Yeah.
as we went along, which is fantastic.
So yeah, so it does. It looks like we did quite well there at.
Oh, there's a question with respect to virtual meetings. I can jump in there. Going back to virtual meetings, do we need to have a bylaw regarding monthly board meetings if all board members are in agreement to hold by Zoom? Great question, actually. Right now, again, with the temporary provisions under the Act, there's no obligation to have consent of all board members to have your meetings virtually. So in the legislation, there is an entitlement to have board meetings virtually, provided everybody consents. That's generally there before, after the pandemic, etc. You can have electronic meetings, but again, without the pandemic temporary provisions, you need everybody's consent. So right now, until May 31st at a minimum, you don't need to have the consent of all board members to do this. We have, as I was talking about earlier, CCI, Ontario Legislative Committee, have made submissions to the government to allow that to continue so that we don't have to require the consent of all board members to continue to have virtual meetings, because there are some concerns that we could have one board member stymieing the ability of the corporation's board of directors to have virtual meetings going forward. So we'll see where we land after May 31st, but for now you're good to go.
Perfect, thank you, Nancy. So want to thank, as we close out here, I want to thank all of our presenters this evening for joining us. We've got Cheryl Wood and Nancy Houle from Davidson Pool Allen. Thank you guys so much for helping out. Megan Malloy from Elia Associates, thank you. And Noah Johnson from Sentinel Management. Thank you guys so much for helping out this evening and presenting. We also want to thank our sponsors. Big thanks to our sponsors, Carleton Electric. We have Davidson Houle Allen, Douglas Fire Safety Systems, Elia Associates, Normac, Sentinel Management, and Upper B. You are also going to get a survey at the end of, or at this evening, some point this evening, you'll get a survey in your inbox. We'd like you to take a few moments and provide your feedback on what you thought of our presentation this evening. And you'll see on the screen here, we have some upcoming events from CCI over the next couple of months that we would please check out and join us for those events. Thank you everyone so much and have a great evening.
Thanks, Eileen.
Thank you.
So Shelley, as your host, I think you'll end our session for us. Good night, all. Stay safe.
Thanks.